A little bit about me, as I've already said. We'll move on. So these are the 4 legal protections, or the areas rather of legal protection that I wanted to cover today. As I said, your brand, your product, your customers, and lastly, your business. So, your brand. Now, I know a lot of you will have already heard of IP protection. You'll understand that it's incredibly relevant for fashion and beauty brands, but I can't emphasize how much this is really core and really vital for you getting onto the global stage. You'll know that most of the successful fashion, or all of the successful fashion and beauty brands, are known by their brand and the reputation that they have built up behind that brand. Whether it's Louis Vuitton, Chanel, we're all familiar with those names because a lot of time and energy and creative power has gone behind building up a reputation, goodwill, and a following behind that brand. Now, in addition to those sort of intangible aspects, the brand has also been developed through things like a logo, an actual brand name that the company trades by. Sometimes there are different product names. So if we think about Apple products, for example, you've got the iPod, the iPad, all of these things are capable of being protected. Some brands also protect shapes and colors that they may use. We're all familiar with the Louboutin red on the soles of their high heels. That's actually protected, and it means that if any other company tries to use the same color on the heel of their high heel shoes, then they will very quickly receive a notice from Christian Louboutin, letting them know that they're in breach of their intellectual property rights and asking them to cease and desist immediately. So I really want to drill home to you the importance of protecting your brand with intellectual property rights. That is exactly what they're there for. They're all about creating your creative work and allowing you the opportunity to make a profit from that work and exploit it to the exclusion of everyone else. So let's move to the next slide. Right, so here we're going into a little bit of more detail to what the various relevant intellectual property rights are for a fashion and beauty brand. Now, the first and the most important one is a trademark. I'm sure many of you will have heard of this, but the trademark is essentially the intellectual property right, which will allow you to protect your brand name, your business name, if that's different, any logo you've produced, any product name that you use, as well as any distinctive slogan. Think "I'm loving it" McDonald's, that's a slogan that they've protected, or "Just Do It" Nike. Also, potentially the shape of your item. Here in the UK, we love Toblerone chocolate. I don't know if you've seen that, but it's shaped in a pyramid packaging, and the chocolate's also shaped in a pyramid shape, and that's protected through trademark. Also, any distinctive sounds and colors. So I've already mentioned Louboutin red. Burberry's brown, red, and checked pattern is also capable and protected. Other things that are relevant there. Sounds is sometimes quite difficult, but I try and think of one that you will have heard of. Many of you, I guess, are cinema goers, and at the beginning of some of the Fox 20th Century movies, you hear a lion roar. Now, that particular roar is protected, believe it or not. So anything that is particularly distinctive about your product, your goods, the way it is that you just differentiate yourself from your competitors, those are the things that you should be seeking to protect. And a trademark is the most relevant form of protection for all of those things that I've mentioned. So moving on to design right. This is another form of intellectual property protection that might be relevant for you, and it relates specifically to the aesthetic appearance of your product. So, for example, as I put on the slide there, it could include your fabric patterns. It could also include, for example, the shape of a shoe leg. And some examples to help bring it to life for you are Chanel's classic flat bag, also the Birkin bag, many of you will know of that one, but also Cartier's love bracelet. It extends to watches, any product that's of an aesthetic nature, that has an aesthetic to it, where you have created something distinctive and you want to protect that, is capable of being protected by a design right. The great thing about the design right is that, unlike some other form of intellectual property rights like patents, even if you have already released your product to the world, it is not too late for you to then get that protection. So what I've seen some businesses do is, obviously you put out a lot of product as a business. Every year you're thinking of new creative ways to differentiate your products. And it might only be after you've put something out in the market that you see the traction that it gains, whether or not it's popular. And if it is very popular, then that might be a good sign that that's a particular design that you should be protecting. And you'll have up to 12 months, depending on the country that you seek to protect it in, to do that. Finally, copyright. Now, this is something that arises automatically to protect your creative work. So it's not something that needs to be registered. It already exists the moment you put pen to paper. And so, as I've listed there, some examples of what are protected by copyright are text, such as your product descriptions, any photographs or images that you take, drawings that you make, such as your design documents, marketing materials, and also your product packaging. There are more listed on the slide, but the idea here is really to make you aware of the fact that you are creating these IP assets which are of value. And so making a note of what you create, making sure that you are protecting them where those protections require registration in your country, and then also ensuring that you think about how you can exploit those IP rights is really important. Now, the great thing about registering your intellectual property means that you then are in a position to prevent anyone else from using your trademark or your design or your copyrighted work without your consent. That means that if you spot someone in the marketplace doing something that you think infringes upon your rights, you can send them what we call in the industry a cease and desist letter, which essentially tells them that you have the right, the exclusive right to use that particular name or design, whatever it is, and that you demand that they cease using it with the threat of legal action behind that. Some companies also charge a fee. They say, well, you've already been using it for a week, you therefore owe us X amount, pay it, and we won't take this any further. The other thing to mention is that, unfortunately, you have to register these rights in each of the different countries in which you seek to have protection. So if you're thinking about going global, you'll want to not only have a look at registering in your local country where you currently are, but also the other countries that you're thinking of expanding into. Now, I'm guessing that many of you are already in business, but for those of you who are thinking about it or thinking about a new product or brand name, it's really important that before you put the time and energy and resources behind building that brand, that you first make sure that nobody else has registered it as a trademark or other form of intellectual property for themselves. Now, that's because if you go out in the market with something that is in violation of someone else's rights, then they can, of course, send you one of those cease and desist letters and stop you in your tracks, which is obviously very distressing if you've spent time and energy and money, frankly, building up a brand, a following on social media, all of the paraphernalia and brochures, marketing materials that you may have printed. So it's important to check before you choose a new name that it's, number one, capable of being registered, and number two, has not already been used or protected by someone else. So let's move on to the next slide. Now, here I have listed some of the legal documents that I recommend you put in place if you haven't already in relation to your brand and your IP, your intellectual property rights. So the first is IP assignments. Now, many of you may employ people, whether it's direct employees or a freelancer or a consultant that you bring on. It might even be an intern who's not paid by you, but is doing some work experience with you. But all of these people are producing work, creative work, which you may believe belongs to you and your business, but actually if they haven't entered into an agreement with you, specifically stipulating that any work that they do create whilst working for you, the intellectual property rights within that work belongs to you and not them, then you leave yourself open to a claim later on that the wonderful design that intern created, or the designs that your design employee created belong to them individually and not you and your company. And the way that you avoid that risk is by making sure that you have all of the people who work for you, from the interns all the way through to agencies, consultants, freelancers, and of course your employees, that they all enter into a service agreement. And within that service agreement is what we call an IP assignment clause, which makes clear that any IPR that's created in the course of their work for you automatically is assigned to you, your business. And the second agreement I wanted to highlight is confidentiality agreements. And this is because there are also some forms of intellectual property which are not capable of being protected in the legal sense by an intellectual property right, but are nonetheless really important. And by this, I'm talking about the really commercially sensitive information that you have within your business. So these might be information about your customers or your suppliers. It might be information about your product launches, that kind of thing, your marketing strategy. Anything that you wouldn't want your competitors getting their hands on, that is commercially sensitive information, which should remain confidential. And so you also want to make sure that the same people, anyone who works for your business or who provides a service to you and to whom you're providing access to this information, enters into a confidentiality agreement, also called an NDA, non-disclosure agreement, to make sure that they are legally obliged to keep that information secret. And it may even be prudent for you to make that obligation continue until after they've left you, depending on how sensitive that information is. Lastly, I wanted to touch on brand ambassadors, because I know that this is a popular way that people are using to promote their brand and get awareness about their particular products out there. We know that there are influencers now that have great followings online and that have the power to take your product from, relatively unknown to a global phenomenon overnight. But there are some intellectual property implications to think about. So making sure that you enter into an agreement with them, which makes clear who owns the intellectual property rights in the work that's created. So for example, if you create a flyer which has their image in it, who owns that? If they post about your product and it's a picture of your product and them using it happily or just spooning it or whatever, making sure that you have the right to use that image, because what you don't want is to be, paid a whole load of money for an influencer to post and then that's it. You can't actually work on that momentum and use those posts to continue the buzz, continue getting people interested in your product by reposting or posting elsewhere. So you have to make sure that you've got the right to do that by getting them to agree in that agreement that you either own the intellectual property in those shared materials, or that they will grant you a license allowing you to use their intellectual property to enable you to do that. Okay, let's move on. So the next item we want to talk about is your product. And by that, what I really want to get at is understanding what are the legal requirements for you putting your product out there in the marketplace. And so, as mentioned on the slide, these revolve around labeling requirements and safety standards primarily, which is obviously relevant in the fashion and beauty industry, more so for the beauty industry when you're talking about products which might sit on the skin and then obviously be absorbed, but even with clothing. Let's move on. Right. So some of the labeling requirements that will apply to your product relate to the nature of the product. Now here, these labeling requirements, I should say, are put in place by governments, and they sit in legislation which has been put out there essentially to protect consumers, to make sure that any products that a consumer buys are safe for them to use in the manner that it was intended for them to use it. And so the nature of the product itself is something that is obviously very important and must be included on the label. And by that, I mean information about the components of the product. So if it's textiles, if it's a piece of clothing, for example, it's about the fiber content. You know, there may be some people who are intolerant to certain fibers. They need to know what's in there. And then obviously, if it's a beauty product, then we're talking about ingredients here. The other thing that I wanted to mention is that there are some regulations that apply to certain categories of fashion products. For example, in the UK, it's well known that if you sell nightwear, so anything that someone's going to wear to bed, then you must, within the product label, include information about how flammable that product is. And I'm sure someone very sensible put that rule there. I'm not sure why it exists exactly, but obviously you need to know that that is a requirement, because what you don't want to happen is for your items to be pulled off shelves, or worse, for you to receive, well, I don't know if it's worse, it's just as bad, for you to receive a fine or a sanction. These obviously hits to your reputation and your brand that you don't want to suffer. Maintenance of product. So here we're talking about information on the label which allows the consumers to understand, once they've bought this thing, how do they care for it? So if it's clothing, you know, how do they wash it? What temperature, you know, all of those sorts of things. And if it's a beauty product, what's the sell-by date? That sort of information. Now, you, of course, will need to do your research to get the specific details for your particular product in your country and in any other countries that you seek to do business in. But what I would say is that the best thing to do is to adopt the highest standard. So it might be that there are different standards between your home country and some of the countries that you want to export to. And so the best thing to do in that situation is to adopt the highest standard so that you're not prevented from selling anywhere that you want to sell. I'll just make a quick point about ethical and desirable labeling as well, because this is very popular now, but it has stung some companies in the tail. And that's because they've wanted to look good to the consumer. And so they've put some labels within their branding which suggest that their product is in some way more ethical than their competitors. So as I've said on the slide, it might be claims that your product is ethically sourced, or that it's all handmade, or that it's all originated from a particular place. You've got to be really careful with these, because if you can't stand behind and verify them, then there's a risk that you could fall foul of the regulations and end up getting a fine or some sort of penalty, or just bad press, really, for misleading your customers. And let's move on. A little bit about safety and testing. Again, I would encourage you to look at what specifically applies to your product, but just be aware that, of course, there are strict and stringent rules around the safety of your products, requirements for you to have tested them, and those requirements will vary, but typically they require some sort of independent, verifiable testing. It's specifically or particularly stringent in the cosmetics industry, and because of the scope there is for potential damage to consumers. Obviously not what you intend, but sometimes people have incredibly sensitive skins or conditions that are incredibly rare, and you can't always foresee what might happen. So a good consideration might be to consider getting product liability insurance. And that's the kind of thing that will protect you in the event that one of your customers suffers an adverse allergic reaction or some other medical complaint as a result of using your product. And we've all heard the stories about, big brands who've got lots of money to put behind testing and do put it behind testing, but even them falling foul of these rules. I was reading recently about Johnson & Johnson having had its products pulled recently from the shelves, and this in particular was in relation to baby powder, because the FDA, which is the US regulator in this case, had found traces of asbestos in Johnson's baby powder. Now, of course, that is a PR nightmare for them, and they'll be working really hard to try and convince the public that their products are safe. But you want to avoid getting in that kind of position because, you know, as a smaller brand, that could make or break you. Okay, so let's move on. I should add that if you do have any questions, I'll leave some time at the end for them. So please do ask or save them up. Okay, so now we're moving on to your customers. And as you'll see from the slide, what I'm getting at here is the fact that consumers are powerful. Many countries have put in place laws that favors the consumer. They will imply certain things in your sale contracts in order to protect them and for the consumer's benefit. And so making sure that you're aware of what those are is key, because you don't want to fall foul of the regulations for the reasons I've already mentioned of, you know, receiving penalties and fines, but also the reputational problems that that can give rise to. So let's have a look at this in a bit more detail. Pricing. Now, this is something that's been quite notable in the past few years here in the UK for sure. And it's about making sure that your consumers are not misled by any pricing strategies that you might seek to use to convince them to buy your products. And by here, I'm talking about where people offer money off deals or percentage discounts and make it seem as though they're getting a real bargain because this product that was $100 is now being sold to them for $10 for 5 days only. It's a bargain, grab it now. And there's lots of regulation in most countries around what you can say around pricing. And the idea is that they want it to be transparent and accurate and not misleading to consumers. So, you know, if you're claiming that you're offering a sale and products are being discounted, then you need to be able to show the original price was a price that was open to the market at some point, so that you can actually prove that your discount is valid, is a real discount as opposed to something you've just made up. Refunds and replacements. Now, this is going to vary from country to country because the rules are slightly different. But in most cases, if you deliver a product which in some way is faulty or doesn't comply with its description, or fails to work in the way that it's expected it should work, then your customers are entitled to, and now, of course, it depends on just jurisdiction, but either a refund or replacement, a credit note, or something of that nature. So understanding what the rules are is really important to make sure that you don't end up in a position where you think, you know, oh, it's a sale, so I'm not offering a refund, and that's going to fly, and then it doesn't. You report it, and then you have to deal with the bad press plus the sanctions from the regulator. Data protection. Now, this is something that's becoming more and more important. And it's because of the way that we're all shopping nowadays. You know, I've got a picture there of a woman shopping online because that is where a lot of the action is happening. And with the lockdown we're all experiencing at the moment, I'm sure that trend is going to continue. We're all getting used to doing everything online. And so the online trend is going to explode and continue to explode. And what it means is that companies who sell products, especially fashion and beauty brands, are able to gather a lot of data about consumers, whether it's things from, you know, the usual personal information, so names, addresses, credit card details, dates of birth, that sort of thing, but all the way through to their purchasing behaviors. So what's their browsing history? What have they purchased in the past? What are they likely to purchase in the future? How can you track them online so that your advertising is visible to them in all the right places and at the right times to get them to buy? And, you know, every day we're hearing about more and more sophisticated ways of manipulating that data in order to make a sale. And so the law is catching up slightly. It's not quite, it's always lagging behind. But the regulators are very clear that they want to make sure that any use of personal data is reasonable and secure. I think secure is the important point. You will have an obligation to keep any personal information that you have secure. So thinking about the protections that you have against hacking and other cybersecurity threats is important. But also having a privacy policy, frankly, which is really clear and enables consumers who deal with you to know what data you're collecting, the purposes for which you're collecting that data, and how you're going to use it. Where is that data going to be stored, and what can they do if they want to opt out, as we all call it nowadays. So being aware of that, knowing that it's going to be a growing area of regulation and scrutiny, don't be afraid of it. Definitely gather as much data as you can. Data is a new oil, as they say. It's going to be really important, but be clear about your obligations. Make sure you keep it safe. Make sure that you're not spamming people, that people do have an option to unsubscribe if that's what they want, because you don't want regulators to clamp down on you. You want to make sure that your business also maintains a clear reputation. Okay, let's move on. So now we're talking about your business. And by this, I mean really your business model, or the way in which you structure your business. And as I've said there's a number of different ways that fashion businesses can operate. And I'm sure you've already heard about this from some of the other speakers, and you'll hear from more who are to come. But it's really a good idea to think about these different options, especially if you're thinking about going global. You have got a number of options. So really just thinking through each of them and figuring out which one is right for you is a really good idea. So I'm going to talk through a few of the different options that you have now. And here I'm specifically looking at and thinking about those of you who want to go global, who want to provide your goods and services to a larger audience than you're currently providing them to, a geographically dispersed audience. So, online. Now, I've just been saying that this is obviously a really popular mode of selling, but it's great if you want to go international at low cost. Why? Because we know that being online is incredibly cost effective, especially if you're able to combine that with outsourcing some of the more tricky and costly elements of fulfilling your orders. And so by that, I'm referring to your delivery, customs clearance, currency exchange issues. There are a number of businesses who offer that fulfillment role. They'll take a share of your profit margin in return for that. But it means that, especially if you're in the early stages of providing your products to an international market, that you're able to do it quickly without a huge investment up front, at relatively low risk to you, to test out the market. So it might be something that is worth considering as a first step. It's obviously quite pricey, and so is not perhaps the best long-term strategy, but a useful first step for some of us. Okay, and then the next option is agency. So in the US, you probably know this as a sales rep, but the idea is that you find someone to work on your behalf to find your customers. It may be that those customers are retailers to stock your product, but whoever they are, the idea is that this agent will have connections within that market, the ability to sell your product on your behalf to that customer. And then once they actually sign that customer up to do business with you, they are entitled to a commission, which is usually a percentage of the sale. Now, the useful thing about this particular relationship is that you own it. So you will be entering into the relationship, or the contract, I should say, with the customer. You will be supplying the product to your customer, so you keep that relationship going after you've had that introduction. Another option is to have a distributor, known in the US as a reseller. Now, this situation is slightly different in that what you're actually doing here is selling your product to the distributor or the reseller themselves, who will then go out and find customers or retailers or wherever they are in the supply chain, the next person along to sell it to. Now, this is also useful because often it can lead to a bulk sale for you, but you don't really have control over what happens after they've bought your product. They will, of course, want to sell it at a markup, and you may or may not have control as to how much that markup is. And that might concern you. You might also be concerned about, the way in which they're marketing your product. And so it's not going to be useful for everyone. But it might be, especially if you have a high volume product and you really want as many channels as possible to get out there. Next, we're looking at IP licensing, and this is a bit more involved. Essentially, you're licensing out your IP to someone else to potentially not just buy products from you, but produce the products themselves. If you've, for example, given them the design, then they're able to go ahead and make your product themselves and then go out and sell it and then pay you in return for that license. And then finally, I wanted to touch on franchises. Now, these generally are more useful when you've got a really strong and established brand, because the whole point of a franchise is that you've already got such goodwill behind your business that others want to be able, they want to come in on that. They can see that people are already wanting to buy the product, and so they want to become a franchisee in order to be able to benefit from that goodwill. So perhaps not so useful when you're just starting out. Okay, let's move on. Aha, standard terms. Now, of course, your business is your money. And so what we need to do is to make sure that you're protected from the risks that exist when you start trading. And a lot of this are around, late payment or non-payment in some cases, because your counterparty might experience difficulties. Other issues that may arise that you want to protect yourself against, because, ultimately, your cash is king, and without that you don't have a business. And so being able to protect that aspect of things, making sure that money's coming in, you're protected from things going wrong, is key. The best way to do that is to have a standard contract. This is a contract that you put together specifically for your business. It anticipates the particular risks that you face. So it requires you to actually sit down and think about, okay, what has gone wrong for us in the past, and what do we want to try and prevent from happening again? Or at least put something in place to reduce the risk of it happening again. It's tailored for you, so it reflects the way that you do business, which is important, because I've seen a lot of businesses repurpose contracts that they've found online or that they've used from a competitor or a former employer, which essentially don't reflect the way they do business, and so unfortunately aren't really worth the paper they're written on. It requires them to do things like write notices and what have you, which they never do, and so they're not able to trigger the rights to do things that would protect their business. So making sure that you've got a contract that actually reflects the way that you do business, so that it is of use when you need it, is key. And so that means you've got to have a written contract, and it means that it needs to be signed before you start working. And this is important, again, because I know that it can be tempting when you get a new deal to start working on it before everything is signed, but that's exactly the situations where you leave yourself open to huge risk if things don't go quite as planned. And as we know, in business, it's quite common for things not to go quite as we've planned them. So making sure you've got a written agreement that is agreed, understood, and signed from the outset is really important. And some of the things that you might consider putting in that agreement, so as well as the obvious things like the product quantities and the price, are things like covering off late payment. So really stipulating what happens in the event that your counterparty, your buyer, refuses to pay on time or is unable to pay on time. You want to make that really as unattractive and painful as possible for them, so it doesn't happen too often. So thinking about charging interest, whether it's a certain amount a day that is charged for each day that the payment is late, Or thinking about whether, if it's an ongoing contract, you can stop supply until they have made the payment that was due. That's a really powerful way of sharpening people's minds and getting them focused on the need to pay you, because they're not going to get anything else in the meantime. But if you haven't put it in the agreement, that non-payment is an event upon which you can stop supply, then it can be difficult for you to try and do that at the point that they stop paying, because there's no, you haven't reserved the right to do that within your agreement with them. Some of the other things to think about, if you're dealing with someone that's a particularly small business, or someone that you're not sure about their credit worthiness, perhaps, then you might want to think about getting some kind of payment on account, and whether that's as a deposit or payment towards the final bill. These are all the sorts of things that you'll need to think about in advance when you're putting together your standard contract. Retention of title is also an important one, because you've got physical products here. And so you want to make sure that in the event that your buyer isn't able to pay or doesn't pay, that you're able to get back those products and resell them onto someone else. And one way you can do that is by providing in your contract that you retain the title in the goods until payment is made. So even when those goods have left your offices and they're on their way to your buyer, if they don't actually pay, then the title in those goods never passes over to them. They're still yours. You can go and pick them up and then resell them to someone else. And then finally, I've put limit your liability. Now this one, I hope that it will never be an issue, but sometimes it is. And you can find yourself in a position where, let's say you've struck a contract which is worth, let's say, $50,000 to you. But because of things going wrong in your supply chain, you not being able to deliver on time, your buyer is trying to bring a claim against you for $1 million. Now that obviously does not make sense. The contract was only ever worth $50,000 to you. And really they should have been trying to mitigate the risk that they would face if they didn't get those goods on time, so that they weren't exposed to $1 million liability. But to protect yourself, you can put a financial cap within your contract, so that if there is any breach that you're responsible for, you know that you will never be liable to pay more than the value of the contract, say, or it might be a particular figure amount that you want to put in because that's the amount of insurance cover you have, or it might be a fraction of the contract amount. It's whatever's relevant and for your business and typical for you.
Thank you so much, Rashida. This was fantastic. Everyone, please go visit strandsahara.com if you want to learn more. Rashida, thankfully, will be sharing the slides that she walked us through today. And please do follow her on social media. She is the go-to person if you want to take your startup on a global level. So definitely up and stay connected. Thank you so much, Rashida. We're so grateful that you spent time with us. Thank you.
Bye.